5-2, you were charged with the third-degree felony. Choking a family member. Who is Rashona Caesar?
She was my girlfriend, but
Where is she?
I'll talk to her. I can't get incredibly bad.
If you did, your bond would be revoked and you would sit this out in jail until we resolve it, you understand? Because the rule is that defendants shall not have contact with the victims unless otherwise allowed by the court, because too many problems occur.
Yes, sir.
And manipulations happen, and it's not fair because when a grand jury indicts, then the proceedings are in motion and then it has to follow the rules of law. The people involved, even though they're involved, they still lose certain freedoms, such as trying to negotiate on the side. That's what has to be done through your lawyer and the other lawyers, so that there's not any problem of allegations of force or people who are trying to influence the proceedings improperly. So, and when somebody puts their hands around someone and chokes, there's only one intent, and that is to kill.
Eliminate that.
That's why this is such a serious crime. That's why the legislature has made it a third-degree felony, which carries with it up to 10 years in prison if convicted. So, with all that, what are we going to do?
Judge, I have had appointments for a phone call set up with Mr. Lawrence a couple of times. I think that we've missed each other. I tried to call him the last couple of days. I have not been able to.
You're always great with what you do, but I'm not going to wait on him to decide to call you.
I understand, Judge. It's me calling him. I've just missed him. I don't know if it's
Well,
scheduled or something, but
that's his problem.
I need some more time to.
She's your lifeline. You need to be in contact with her. She shouldn't be hunting around town to find you.
Yes, sir. She did.
But that's okay. We're going to move forward without y'all contacting each other if that's what's necessary, because we're not going to wait on you and your convenience to contact her regarding your life and whether you might be going to prison for 10 years or not. That's important. It would be for me. Maybe it's not for you, but I know we're going to move forward. This is set today. What's it? It's set for an announcement. What do y'all announce?
Judge, I need 4 weeks to talk with him, to review this with
I
him.
know it was set a month ago, reset a month ago. And we can't wait. That was 5 weeks, actually 5 weeks ago. And he hadn't contacted.
Yeah, I have.
He contacted my
Over
office.
and over and
We have-
persons. So there's like.
Well, I'm not going to wait on y'all to try to figure out an answer. I'll give you 2 weeks. 2 weeks, okay? Get a resetting. Zachary Poole.
Judge, we have a deal worked out. I have not been able to go over his.
Where's
paperwork
Mr.
today.
Poole? Is that him?
Yes, that's him. If we could hold him so that I have.
All right,
time to
Mr.
go.
Poole, just have a seat. She's going to get with you here in a little bit. Thank
Yeah.
you. It's 2 cases, right?
Yes, 2 cases, Judge.
Okay. I've got Maynard Sorto. Is that Maynard Sorto? Was that so you're 25 or 0? Where's Maynard Sorto? Is that him?
Yes, sir.
Come on up. You're Maynard Sorto? Have you talked to this lady, your attorney?
This is our initial appearance, Judge. This is my first contact with him. I'm getting good contact information from him today, providing my information so that we can figure out what to do going forward.
This one is another one that was set 5 weeks ago for
Just like I told you about, I have disease.
resetting.
Judge, it's an initial experience. So
Yeah.
my docket, I have not had contact with this man.
The initial, it was, the initial docket was 9, he was here at 9/24/2025. But when are you gonna talk to her? She's not gonna track you down. You gotta talk to this lady. She's unless you want to represent yourself, you're looking at a third-degree felony of evading arrest or detention, which carries with it up to 10 years in prison, which is serious, if it would be for me. Maybe it's not for you, but I think it ought to be serious. I would be contacting her all the time to make sure that I'm getting that.
I haven't even.
Hold on, only one of us can speak at a
I'm sorry.
time. This lady takes everything down, and when two people speak over each other, she can't, the court reporter can't do her job. And the Court of Criminal Appeals says if somebody interferes with her job, then they get held in contempt of court. And we're not gonna, let's be polite. You're gonna get a chance to speak. Do you know how to reach her?
No, he does not, Judge. This is the first time that we've met each other.
Communicate
Yes, sir.
and move forward. But this one is another one that you need to be very careful. I don't see a prior conviction. Have you ever been convicted of anything before?
No,
Well, this could be fixable,
sir.
you know,
It's my
but she's
first-
your lifeline and
Been going through a lot.
welcome to planet Earth. Everybody's got everybody's problems. Sometimes it's more difficult times than other times, but it always, that's the way for everybody. Bad times, good, and dealing with the bad times. If it's a difficult situation, she is great person to be your lawyer. She'll guide you through this. And, but if you make, you know, we're all held accountable when we all make mistakes. When we make a mistake, fix it responsibly, move on and don't make the mistake again. And that's the test. Not because you made a mistake. The test is how do you deal with your mistake? Responsibly or irresponsibly? It's your decision, like all of us. So get this fixed and get some of these problems you have with your life fixed and smoothed out and then move on and be the best you can be. That's because do you have any prior convictions? No? Well, don't start now. Fix this. What do you want to do with your life?
No.
I mean, what do you want to do? What do you want to be? You know,
I want to get in plans.
sir?
I want to get in plans. And
In the plants, like.
Oh, the refineries?
T-bone.
Okay, do you have a skill or a training?
I want to be welding.
What about it? Have you gone to welding school yet?
No, sir.
Oh, okay, that's a great job. Well, and
But I need to, degree and stuff first. So,
associate's degree, 2 years.
Oh,
You can get something like that. All right. Well, anyway, talk to her. I'm gonna give you 3 weeks.
Can we do 4, Judge? I'm not sure if the other one was meeting.
All right, we'll set out
Office.
for 4.
Thank you.
Get a resetting.
Up here, son. Up here. Right here.
And Craig Stansberry.
He's here, Judge.
I'm right there for you.
I know Stansberry's from Groves. I went to school with them. They're all good people. Stansberry's great people. I'm sure you're probably kin to Stansberry's from Groves.
He's-
And you're looking at third-degree felony intoxication assault with a motor vehicle. And it could have been worse. You know, somebody dies in a situation like this, you're looking at manslaughter. So this, if convicted, is a third-degree felony, then you're facing up to 10 years in prison. And so where are we on this?
Judge, this is my first setting with him. I'm still working through the media. I want to have him at.
Show me announcements on these things.
Today was supposed to be an initial, but
But it was just, it died in August, so
right. That's correct. So it's
I
still
always give it 3 or 4 months in one, but so how much time? 4 weeks?
4 Judge. Whatever you between.
How about 4?
Okay, we can do 4 and come back and see where we're at.
Okay, do we need to deal with anything else with Stansberry here now?
No, Judge,
I
he's
guess-
clear on his requirements.
We affirm that he's gotten what he needs for his car, Judge.
And you have to have an interlock device in any vehicle you operate. That is a condition of bond for this type of offense. While it is pending, do you have that?
He does not have his
Well,
own
you-
vehicle.
Okay, somebody driving you?
Yes, his wife is here, his
And
wife
you
drives.
don't have to have one if you don't operate a motor vehicle, but sometimes you're in a position where you need to go somewhere And that's not going to be an excuse if you don't have it available in a vehicle. And it costs some money and you have to blow into the device before it'll let you start. And it's got to test you to make sure that you're sober, which is what has to be done in every case like this. So,
And he's clear on those requirements.
all right, get a reset and thank you. I've got,
Jeffrey?
hold on Mr. Stansberry. I've got two other cases.
Yes, that's correct.
They're all the same.
Out of the same incident.
All the same, I'm right there.
I thought.
And then we have Mr. Poole that I'm working on paper
Okay.
with. Thank you.
24 CR 1639 is called. You're, is it Brighton?
Britain, yes, sir.
Britain. And are you still at 1500?
Yes, sir.
Okay. You're charged with the state jail felony, which carries with it up to 2 years in the state jail. And
This is going to be refiled as a misdemeanor, Judge.
there's not a lesser included. How that fits in? Without having to refile?
Yeah, we have to refile.
What's the state? Is it a class A misdemeanor?
It'll be, well, the harassment will be Class B misdemeanor. It'll be a 2-year probation. So we'll refile it, get it taken care of.
Okay. Well, we handle misdemeanors here too. So
Doesn't matter, Nick. Yeah, this is.
yeah, you're gonna file an information, I guess. Yeah, we can do it here. And then we can.
You do original.
Oh,
I have jurisdiction for.
I just figured that out because if we refile it, usually when we refile them, we give them misdemeanor numbers, which means that they go to a misdemeanor court. And I don't know if they can give it a felony number.
Judge, I'm not sworn in under the county clerk to do their payroll.
Yeah, I don't want to do theirs. I want to do ours, but I thought since we have. This court has jurisdiction that the other criminal district court does not have for misdemeanors. We can handle that. And we generally do it on lesser included. That's why I was looking to see if somehow we could pull that out.
You can't do an
I
harassment.
don't see the word harassment in the allegation, so. Yes, but anyway, y'all get something done and then just send it to us and then it'll be dismissed.
It's right.
Is that, okay, will we review it in 4 weeks?
That'd be lucky.
Okay,
Thank
can I
you.
get reset? That yellow thing, I thought you were about to measure somebody for a suit.
I can if you want me to.
You know, when we,
Actually, nice.
dealers or something, they're always wearing that tape measure around their necks and, you know,
Some right there.
measuring,
They come up
measuring
with-
people's waistline.
Actually did that for a bit.
You only measure your waistline?
You waistline and dancing.
But you want to get your waistline measured on YouTube, do you?
No,
No, I don't.
that's gonna be the.
I don't think anybody does.
Restitution.
Doing okay this morning,
I've got yes, sir, I've got,
Mr. Cannon, please
Mr.
testify.
Cannon.
Swear or tell
Yeah.
the truth, whole truth, and nothing but the truth that you got.
Ma'am.
Okay, come over here. You get your right. Okay, 15 each. Right, place it flat right here. Don't roll it.
what are we
I
doing
need to
both
mark that
cases or
from
what?
seeing this.
Both. unfortunately.
Yeah. That's
Trying to get one, but
the game.
the state wants to go to.
Place it flat right there.
Standing.
Do it.
He's that kind of guy. Two's,
Okay.
Your
that's
one's odd.
better. Let's get one more.
two's even. He's an even kind of guy.
Yeah, same one. Okay, place it flat
We
right
have two
here.
different victims, right?
That's correct, Your Honor.
Yeah, that's,
Same
that,
incident too.
that would make sense. Yes, sir.
And we just split the restitution down the middle.
It's a mother and daughter and they live together and it's
Judge.
Two cases are now called. Cause numbers 25 CR 398 and 399, the state of Texas versus Cullen Rayford Cannon. You were Mr. Cannon. With Mr. Turk, your attorney and the state's attorney. You were charged with the second degree felonies in each case. We're only going on paragraph 1
that's correct, Your Honor.
and of aggravated assault with a deadly weapon. Does the defendant waive formal readings of the indictments and the arraignments here? Can we proceed in summary?
We may judge.
In summary, these indictments allege Similarly, that on or about February 26th, 2025, in Jefferson County, Texas, you committed the second-degree felonies of aggravated assault with a deadly weapon by driving your vehicle that you were operating and apparently colliding with another vehicle occupied by the victims in each of these cases.
Yeah.
And
that
that in the manner of the use and intended use of the vehicle was capable of causing serious bodily injury or death, which means that's the definition of a deadly weapon under the state of Texas. And if convicted, this is a second-degree felony, which means you are facing no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed on each case. Do you understand what you are facing, sir?
Yes, sir, I do.
Agreements have been reached on each of these cases similarly, right? That you would be placed on deferred or unadjudicated probation for up to 10 years in prison, for up to 10 years in length on the deferred or unadjudicated probation. I have probation or restitution is 15,000 to one victim. Is there restitution to the other?
Yes, 15 to the other.
$15,000 for each victim in each of these cases, totaling $30,000 in restitution.
Yes, sir.
Yes, Your Honor.
Is that your understanding of the agreement for each of these cases?
Yes, Your Honor.
If I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes, I do.
How do you plead in each of these cases? Are guilty or not guilty?
I plead guilty.
Are you pleading guilty in each case voluntarily and because you are guilty?
Yes.
Show you what's marked as State's Exhibit 1. In each case, did you sign those documents? Did you understand them? Discuss them with your attorney? They're the same in each case? And are the contents all true and correct that you signed under oath?
Yes, sir, I signed it.
State's Exhibit 1 is tendered into evidence in each case without objection admitted. Each of these states similarly that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You were guilty of the crimes charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer in each case. All of these are true, so help you God, it states.
Yes, sir.
States Exhibit 1 in each case are made part of the record in each case. Pre-sentence report is waiting.
Yes, Judge.
Court is going to follow these agreements and find, sir, in each of these cases, you are pleading guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt in each case. But I'm not going to do that. I'm going to defer any finding of guilt so long as you follow these terms and conditions of probation, which are for 10 years in length. You do well, it can be shortened to 1/3. Restitution is to be ordered in each of these cases to the respective victims in the amount of $15,000. There will be other terms and conditions of probation, which are normal and customary for these type of offenses. Please follow these terms and conditions of probation. If you fail, your probations could be revoked. You could then be found guilty and sentenced up to the full range of punishment, which means you're looking at up to 20 years in prison. Also, aside on this, a deadly weapon, an affirmative finding that a deadly weapon was used, namely a motor vehicle, is going to be put a finding made by the court. It won't affect this matter unless your probation is revoked. And if you're found guilty, then if you're revoked and then found guilty and sentenced, you must serve 50%, at least 50% of the sentence before you can be considered for parole. Which means if you were sentenced to 20 years on each case, you'd have to serve 10 years, flat time, which is ought to be great inspiration for you to successfully complete probation. Now,
Yes, sir.
these, did you know these people?
Absolutely not. No.
Okay, well, you can't have any contact with them. Sometimes, a lot of times we have, the defendants and the victims know each other, and unless otherwise ordered, you can't have any contact with these people.
I wanted to contact them after the wreck to see how they were to make sure they weren't hurt, but I knew I wasn't supposed to.
Yeah, well, you did the right thing, because that only gets, if it's misunderstood, then you're in all kinds of trouble, because we take care of victims here. Okay, please see the probation officer and you will begin probation. Thank you.
Thank you.